All rise. Circuit Court's now in session. Honorable Pat Syracuse presiding.
Good afternoon, everybody. You can be seated.
That's here.
Sorry, didn't mean to smash that. Okay. Yeah, let me have one of those. All right, we are here in State of Florida versus Curtis Reeves. It's case number 2014-216 CFAES. The charge is murder in the second degree, a first degree felony, and aggravated battery, a second degree felony. And the state is present and represented by Mr. Garcia, Ms. Sumner, and Mr. Lowry. The defense is present, represented by Mr. Escobar and Mr. Michaels, and I see that Mr. Reeves is present in the courtroom. We're here for pretrial, and unlike past pretrials, I don't really have an agenda for today. I have given up trying to shoehorn things the way I want them, so I'm going to go ahead and see what y'all can come up with as an idea for how we can get this case to trial. So the only questions I'm going to ask is about discovery. After that, I am at your service to try and provide a venue to get this trial going. I brought my calendar for the rest of the year. I have blocked off certain days that we can use, certain days that we can't use. I'm provided to give you the venue if you need the time for a stand your ground motion. I'll block off as many days as you decide that we need, and we'll go from there. So, defense, we'll start with you. How much discovery do you have left to do in the way of witnesses?
Your Honor, out of the 100 plus witnesses, we've taken a little bit more than 60 witnesses. We've deposed more than 60 witnesses to date. I think we've got like 41, 42 witnesses left. We've got depositions scheduled through March, and I believe that Mr. Garcia is going to be opening up April. I am hopeful that we can finish all of the discovery, all the depositions, either late April, probably latest sometime in May, depending upon who shows up and who doesn't show up. We've had actually a pretty good turnout. I think we've only had, of this last round that we took, we've only had like maybe 6 witnesses that didn't show up, and those have been rescheduled. I've spoken to Mr. Garcia. I think we're probably in agreement that if the court wishes to set a trial today, I would suggest to the court a late August, September trial date. If the court doesn't wish to set a trial date today, I would suggest a late April pre-trial conference so that we could obviously let the court know whether all the depots had been done and what's left to be done.
Okay. Well, I'm definitely going to set several pre-trial conferences in between now and when we do the trial. Question becomes, you say 60 of 100 witnesses are done. There's witnesses, and then there's witnesses. Some witnesses drove by in a patrol car and got a look at the movie theater. Others were actually civilians inside the movie theater. What are we dealing with as far as, did we just get rid of the low-hanging fruit, or have we gotten to those difficult-to-reach branches where discovery is really key?
The vast majority of the witnesses at least appeared on paper not to provide a lot of information. We have found just the opposite, that a lot of the witnesses that we I can't think of many witnesses that we spent less than an hour with because they had a lot of information that weren't on the police reports, that weren't on the voluntary statements. And I think, Your Honor, that comes from the fact that the officers that were doing the majority of the interviewing there of individuals, patrons in the theater, really didn't know a whole lot about this particular case and were just basically saying, hey, tell me what you know. We were able now to take their depositions, and they knew a lot more than what their statements revealed. So we have gotten into the nitty-gritty witnesses, the important witnesses that appeared on paper to have, very crucial information. But the vast majority of the investigative detectives are still left to be done.
Those are the ones that are going to slow us down. So the question becomes, you're telling me that you're through March and April. How many are left that aren't yet set?
Well, Your Honor, we've gotten dates through the end of March. And so we are now going to be setting, hopefully, the rest of them in April when we get, those dates. So I'm hoping that between March and April, we're able to get the vast majority of the 41 that are left. Again, you're absolutely right. We've been doing sometimes 5, sometimes 4 witnesses, at a slot. I anticipate that's probably going to be, down to 3 and 4. up until we get to the main players, and those will be probably half a day, maybe a whole day, depending upon who it is.
Well, if I were to set a pretrial then in the first week of April, could I be reasonable in expecting to hear from you that every witness has either been deposed or at least has been set once, although they may have failed to appear for their deposition, but every witness has at least been set once and given the opportunity to be inquired of by the defense?
I think if you give me the end of April, I think we probably would be able to say that, and that's assuming, part of the issues, Your Honor, is that we're doing depots on Mondays and Fridays, and, we're doing them, practically all day. And so if we can, squeeze those witnesses in those 2 days between now, and the end of April, I think we've got a very good shot at either being there or coming very close.
All right, and the next question is going to be defense witnesses. Have you listed any? And if you have you provided reports if you have any experts?
We have not listed witnesses yet, Your Honor. We are, starting to, deal with that particular issue in our office. I don't anticipate that our witness list is going to be real large. The majority of our witnesses are going to be, I think, witnesses that they've listed that have said certain things in depositions that now are favorable to the defense, as well as experts. So I anticipate that that's going to be the extent of our witnesses.
And that takes me to my next question about your witnesses, which is, have you and your experts gone on the field trip to the movie theater to do that which you asked me about 2 pretrials ago?
We have, Your Honor, and the Cobb Theater has been very good at providing us documents that we've needed. We've got all of the architectural drawings for not only Theater 10, but many of the other theaters as well. They have been very cooperative in what we've wanted. Attorney Davis has gone beyond the call of duty as far as being able to provide us what we need.
And have you provided what you have now received in reciprocal discovery to the defense?
Your Honor, it's my understanding in speaking to Mr. Davis that has already been provided to them. All of the architectural drawings and what have you have been provided to them.
No. All right. Mr. Garcia, have you gotten it?
No, sir.
All right. Perhaps you gentlemen need to have then a quick huddle after to make sure that everything that you've got that they say or they've given it. Now, because I'd be surprised if they had it, if they haven't already given it to you.
Your Honor, I can only tell you that, I've spoken to Mr. Davis. He has said that, most of this stuff has been given to them. I think he even told me that they actually picked up the entire hard drive and they have now the hard drive in their possession. He also indicated to me that the actual seat that Mr. Reeves was seated in has been taken by law enforcement, which is one of the things that we were looking for. We haven't gotten that in reciprocal discovery, but Mr. Davis has been, quite forthcoming with information about what's been provided. So if Manny doesn't have it, I believe the last time that we were actually in depositions, I believe it was Mr. Garcia, that I showed the architectural drawings, and I believe he indicated he had seen those before.
No. All right, I'll ask him about it.
Me, Your Honor.
Okay.
I had never seen them before, and we don't have a copy of them.
Okay.
We'll provide them.
I was going to say, Mr. Escobar, anything that they haven't provided you, presume that they are complying with the court's order and the standard rules on discovery, and they'll give it to you if they've got it. And if they haven't given it to you, let's assume that they haven't got it, so you give it to them if it's appropriate discovery material. The seat.
Judge,
Mr. Garcia, do you have the seat?
That's a misconception. I don't know on whose part. To my knowledge, the Pasco County Sheriff's Office does not have the seat.
Okay.
We've never seen the seat. So Attorney Davis,
Well, surely you've seen the seat.
the seat where...
At the time, yes, Judge.
Right, I mean, you've been there to see the seat.
Yeah, Judge, I'm talking about see the seat where they've removed it, like Mr. Escobar is saying that they've taken the seat.
Okay,
We have not seen the seat. To my knowledge, the Sheriff's Office does not have the seat.
okay.
And Judge, just my point, I don't think we've received any reciprocal discovery, and clearly it's not up to Mr. Attorney Davis to provide us with discovery.
I understand.
So this is all kind of new stuff suddenly.
That's why I cover these things.
I appreciate you doing that.
This is-
I like to
this
find
is-
out too.
This is why I drive back to town. All right, so let's just put together everything you've got that you believe is discovery that you expected that they had already, but they haven't given you, and let's give it to them. Can we do that in 15 days?
Absolutely.
All right, so within 15 days, all that stuff will be given to them. All right, let's see what else we've got. Your experts, how far away are we from getting reports from your experts that can be discovered?
Your Honor, we won't be able to get reports from my experts until the depots have been done and they've read the statements from those particular depots. They've gotten, obviously, all the other discovery. As we're getting transcripts, we're going to be sending those transcripts to the experts so that we don't wait to the very end for them to read, the volumes and volumes of depositions. Obviously, they're not going to have to read every single deposition, but there's going to be some crucial witnesses that they're going to have to read. So I anticipate that sometime in May, they should be done, reading those depositions.
Okay. That being said, a couple other of the witnesses I'm curious about, and I hate that I have to micromanage discovery, but I just want to make sure that we're moving at a pace that gets us at trial in 2015. Have you set Ms. Olson for deposition yet?
No.
Okay.
We don't intend to set some of the critical witnesses until the very end because we are receiving so much information from other witnesses.
So then, since when we come back here, if I decide to come back in April, if I come back in April, in the last week of April, I have your commitment that you'll be able to tell me everybody has had at least one go at sitting, I can be confident that when I ask you, have you deposed Ms. Olson yet, you'll have at least subpoenaed her for some date prior to, let's go ahead and I'm looking at April 27th as a possible day. That's the Thursday, the last week in April. I could have your commitment that you'll have set her by then.
Your Honor, I will give you that commitment with one condition, and that is that we're given the dates by the prosecution to take those depositions. As I indicated to the court before, I'm willing to work Saturdays and Sundays if it takes that. We work Saturdays and Sundays anyway. I understand they're in a different position, but the problem that they have is that for private lawyers, it's Monday and Fridays. Now, Mr. Garcia has given me 1 or 2 Wednesdays beyond that, but they're under the same constraints. So as long as I get the dates, I will make sure that with all the support that we have in our office, that frees Mr. Michaels or myself or both of us to be able to take those depots. So with that condition, you've got my commitment that certainly I will get those depots done, but I've got to be given the dates because I have no control over that.
All right, I'm going to come to them next on that. Last thing I'm going to give to you here before we start asking the state some questions. Obviously, I received a motion from you that Mr. Reeves has had some issues with his health over the holidays. And clearly, from what you told me at the bond hearing, you're going to make his health some sort of an issue during the trial. I don't think that's an unreasonable expectation. His medical records are private, but if you're going to rely on them at trial, there's got to be at some point an obligation to provide them in discovery. Have you provided any of them in discovery yet to the state?
No, Your Honor, and that's a decision that's going to be made, with our experts at some point later on after we've gotten more of the discovery done.
All right. So that would be something that I'd get a more approximated answer on, say, on April 27th. We go with that day?
Yeah,
Okay.
I think I can give you more of an idea.
Okay. All right, State, your turn. Tell me about discovery. How are things going in your approximation, and what can I do to assist you in making this go faster?
Well, I don't know if there's anything really do, Judge, but I think I have to take a little bit of a comment on suddenly we're supposed to be working on the weekends, and it's our fault that they can't get depots set. I mean, I personally have had conversations with Mr. Escobar saying I'm available to come do things on other days. My schedule is very flexible. And yet I've never had a call to do anything along those lines. So I'm under the belief that we're waiting for them to tell us the days that they want to do it, and we've or certainly are agreeable to most dates that they have openings, so we're fairly flexible. We have other sources other than Mr. Garcia and Ms. Sumner. Our office is very big, and so I'm not aware that we're the ones that are slowing this up.
I'm not suggesting anybody's slowing this up, and I'm sure
the suggestion was made by Mr. Escobar that it's kind of our fault we aren't getting more depots done. And so,
that just hurt.
my ring, I thought it was my phone for a second, but no. And so in that regard, my position is, I understand what you're doing about trying to get maybe another pretrial date where some real definitive things can be said, but I would ask the court to go ahead and get a trial date now, so we have it on everybody's calendar, so we don't start setting it months from now when everyone's calendar changes.
I'm going to give you a trial date today. I'm just working through it slowly,
Yes,
and
sir.
and we're going to get there. It's just I want to hear what all of the events will be leading up to the trial date, so that I've got a realistic opportunity to get into the trial this year. So, April 27th should be very realistic for me to have heard all depositions are completed. If you're now saying that you might be willing to offer some Tuesdays and Thursdays, I guess. Okay.
Yes, I mean, like I said, I think we can make some people available on other dates, but they won't be limited to Mondays and Fridays. And
All right.
I said that.
So we'll get some Tuesdays and Thursdays in there, and can I have your commitment that you'll look into what may have happened to the seat in the movie theater, since it's been suggested that the seat may be gone?
Absolutely, Judge. That's all, question mark. I don't know where that comes from either.
All right. I don't suppose the attorney for the theater's here today by any chance? No? All right. Just figured I'd take a shot. You never know who's here. How about... April 27th, I've thrown it out. Let's turn our calendars on and see if April 27th is a day that we can come back for the next pretrial, for the discovery to be completed from the defense's side, and then we begin adding the defense witnesses, and then I figure another 2 months before I'm going to be able to go to trial after that, at least, because you're going to want to depose their experts, and then that's when... Do you have any experts picked out yet that you know of? No?
I've never been involved in a case where there's this mysterious experts that run everything, that nothing can be done until an expert's talked to. So, no, we don't have any experts. We don't have any experts that are going to tell the jurors what they're supposed to think. I mean, I really don't know what these experts are going to be. So, I'm waiting with patience myself to find out what these could possibly be.
Okay. Well, I'm thinking we're going to have ballistic experts, and we're probably going to have FDLE experts on stippling, and we're probably going to have...
Of course, they've been listed. Those experts have been listed by the state.
All right. So let's say that... I said April 27th. I was actually, as I was looking at my calendar, I meant April 30th. I'm sorry. April 30th would be the Thursday that I was looking at for a possible pretrial at 4 o'clock. That's when I can get this room. I'm sorry that it's late in the afternoon, but that's when I can get this room. I'm not in this courthouse anymore. I'm trying to accommodate everybody by coming back here, but if we did April 30th, last day of April, we would have heard that at least one pass has been made at all the state's witnesses for depots. Hopefully we'll be able to clean up very quickly the ones that miss. Looking 30 days after that, go approximately to May 28th. We should have the state's reaction to anything that got listed by the defense. And the defense will have had everything transcribed by then. Now, how soon after you've completed your depositions can I expect your experts to have provided whatever reports they believe they need, as well as the medical records for Mr. Reeves, if that becomes appropriate, which I think everybody expects are going to be appropriate at that point? How long after that can I count on you for that discovery to be completed to the state?
Your Honor, I'd have to frankly speak to the experts to see what their timetable is going to be as far as being able to get us that information.
All right. Well, as long as they say within 30 days, then we won't have any problems. So we will encourage them and tell them 30 days is our expectation for their timetables. Otherwise, there are so many other great experts available, I'm sure you'll be shopping for them.
Is that 30 days from the 28th?
30 days, no, from the 30th of April. Unless you're telling me,
Judge,
well...
This is a problem. We're doing, our depots through April, and we're getting transcripts. We're waiting for court reporters a couple of weeks to get us transcripts in that.
All right.
It's a difficult...
I understand. So the 28th we'll check in on the 30th to make sure that all the depots are done.
Right.
We'll talk about expectations for completions at that point with the understanding that I'm planning on holding almost monthly pretrials until the trial happens. We'll come back on the 28th at 4 o'clock
That's of May.
of May
Okay.
to see where we are. And I'm going to need a firm date of when those reports have all been handed over, including any medical records. That takes us to June. If I take it out to,
That's also at 4 o'clock.
yeah, it's pretty much the only way I'm going to get this room is at 4 o'clock, so.
Can I ask, and I didn't have this conversation with Mr. Escobar, I have co-counsel here with it, but I don't know, is it more, probably better for you to do it in Newport Richey, these kind of hearings, I mean, just through your own personal schedule, and I'm just wondering whether or not there's more flexibility of that, and the defense would be okay, maybe they aren't, maybe it's further for them, more difficult, but I don't know if 4 o'clock in the afternoon is worse for them or not. Just throwing out that if the court wanted to do these kind of hearings in Newport Richey, I don't think we'd have a problem with that.
I kind of made it my mission to try and keep as much of it here as I can, so this is where it's supposed to be, even though it's been reassigned to me. I want to try and keep it
Okay,
here.
that's fine.
So I'm looking at potentially June 30th to be our status check in June. That would be a Tuesday afternoon, and I'd again get the room for 4 o'clock. And that's when I'll hear what your response is to the expert reports that I expect you'll have gotten. So at that point, when June 30th arrives, I hear what their response is going to be, and now we've got all of your depositions done. Now we've given the state a chance to at least set the depositions, if not complete the depositions, on your experts, if you list experts, and any other reciprocal witnesses you might list. Now, the reciprocal witnesses you're telling me you might list, those are actually state witnesses that you believe have favorable evidence, so these aren't people that need to be redeposed or reinvestigated.
Your Honor, I agree the vast majority is going to be probably some of the ones that we've deposed already, but there may be, a few others.
So you're saying there may be some civilian witnesses that are not listed,
Correct, Your Honor.
but are not expert witnesses that, why can't they be listed now then?
Because we haven't finished all of the investigation through the discovery.
Okay. All right, so here we are wandering through July. What's to keep us from setting the trial in July, Mr. Escobar?
Your Honor, I'm just being realistic. I am hoping that, all the preparation with the experts and, all the visual aids and all that we're going to probably have to have. I want to be cautious. I want to make sure that we have, and then there's another problem. I mean, we've got 100 witnesses out there. June, July, and August, or at least the first part of August, is vacation time for many people. It's going to be crucial that we get everybody here for this particular trial. We just can't, hope that, people don't go on vacation. So I just think it's safe to, if we can do it, the third week of August, I think we'll be, much safer in the scheme of things. I know what these summers are like in trying cases and people going on vacation.
I understand, but this is an invitation to a tea party that you can politely decline. These subpoenas are orders of the court, and this is a murder trial. And this isn't a driving on a suspended license occasion, so if we have to cancel some vacations, we're going to do that.
Judge,
Yeah,
can you have me heard, please?
sure.
Judge,
That's what we're here for.
I just got a trial date on Michael Fitzpatrick from Judge Gardner. We're going to be in trial from July 6th for 3 weeks.
Now, that's helpful information.
So,
I can't
So-
bump a death penalty for this. All right, so then August, he said.
August, as of right now, looks pretty good with me.
Mr. Lowry, Ms. Sumner, August?
Lowry and,
Mr. Escobar, Mr. Michaels, August?
Judge, I would like the third week of August, because I think that the kids go back to school, that second week. I really do think that that's going to help us a great deal with, 100+ witnesses. And because we're serving them with subpoenas, I'm going to do my best to try the witnesses that we have to actually contact them as well. And I don't want to have these problems with vacations, and I think that once the kids are back in school, vacations are over.
All right. Well, then to you, I have a question that actually might help us to put this in perspective. I know that you can't say definitively right now whether you're going to file a motion for immunity under the stand your ground law. I know you can't say that definitively, but I have to set a timetable for you to make that decision prior to the trial. And to that end, if we were to say open up the first 3 calendar days of August for that, you would have already conducted all of your discovery. The state would have already looked at all of your reciprocal evidence and experts. You would have had a chance to sit in on their deposition of those witnesses by the first week in August, and I could break out August 3rd, 4th, and 5th as the 3 days that I would set aside in the event that you file the immunity motion. Again, not suggesting that you have to, not suggesting that you will, but I know that if I set a 3-week trial in this division and clear the time and get the courtroom, that's going to be a problem if on the Monday before you show me a motion for immunity under the statute. So is August 3rd, 4th, and 5th enough time for you to make that decision with the understanding that I would need you to file it 30 days before, so before you leave for your 4th of July break, I would need it filed so that the state could respond with witnesses they needed to subpoena, and I would set out 3 days, which I think, after my review of the bond hearing, would be about the amount of time I would need to contemplate, at least from a testimony perspective, that type of a motion. Is that something we can calendar?
I'll give it my best, Your Honor.
All right, but I'm going to take a 5-minute break, actually, so that you can talk to Mr. Michaels, you can talk to Mr. Reeves,
Sure.
and you can look at your calendar and realistically tell me, because, and the reason I selected those 3 days is, I happen to know all my colleagues will be gone because it's the Circuit Judges Conference, so we'll have the courthouse all to ourselves for those 3 days, which means that I won't be getting in anybody's way, nobody will be complaining about parking, the media won't be tripping over anybody, we'll have more Wi-Fi because nobody else will be using the computer, so everything works better on those 3 days if we can make it happen. So I kind of thought that through before we got here. To that end, if I gave you a trial 30 days thereafter, provided I didn't grant immunity and it was necessary to go to trial, I could start your trial not on the first week in September. Well, it'd have to be the last day in August. It'd have to be a trial starting on August 31st, going through September 18th. The problem is there's 2 court holidays in there. We're running over, I forget which 2 court holidays there. I just had them blocked off on my calendar. What are those? You know what those are?
Labor Day is the 7th.
Labor Day, and I forget what the second one is, but I'm told that there's no court staff on September 14th. So that would leave first week to pick, second week state case, third week potentially defense case and verdict. But we'd lose 2 days. I cannot do this trial in October. I already know I cannot do this trial in October.
We were anticipating the August 17th.
August 17th?
The August 17th, only because that's a conflict for me, the September 16th through the 23rd. I'm going to be out of state.
Okay.
So,
August 17th happens to be the week before the kids go back to school in Pasco County. Do they go back to the 17th or do they go back to the 24th? Who's got kids? What week do they go back? Somebody knows. That is pretty far in the future.
I can try to look it up on the Pasco County School Board website, but it's usually closer to the beginning of August.
No, a couple years ago it was August 22nd. When I was in family law, I always used to block off the week before because that was when a million emergency motions came in on who was going to be attending what school. So I remember it has been the third week in August a couple of times. I'm guessing it's going to be the 17th. That's something we can check on while you're talking to your client about the timeline. 17th would only be 2 weeks after the immunity motion if the immunity motion got filed. I don't have a problem with that. Is there any reason that wouldn't work for the defense?
No, Your Honor.
Is there any reason it wouldn't work for the state? Okay, seeing no objection. All right, let's check and see when the kids go back to school, because if it's the week before the kids go back to school, I have to trip up the opportunity to get a lot of jurors. So I'll go back to my loaner office and check it on the computer unless you've got it already, Ms. Summer.
I'm trying to get it in.
You open it up, Madam Clerk? Internet's slow. Somebody must be using our Wi-Fi.
Everybody's the
It doesn't say, and that's their calendar.
I've got it, I just have to, looks like students' first day is August 24th.
Could we,
Teachers go back August 17th.
could we start the trial August 24th? We'd block off 3 days for the immunity hearing if it happens, August 3rd, 4th, and 5th. We'd start the trial August 24th. We would go through presumably through August 26th with jury selection, hoping to have a panel be ready for potentially going to the 27th, but be ready for openings the 28th. Start with witnesses on the 31st for the state. Go the first week of September with the state's case, presumably. Come back the following Tuesday, since there'd be a court holiday on the 7th. Presumably that would, if there was a defense case or they elected to call witnesses, be when they would place theirs on. Presumably wrap up, go to closing on September 11th. It's a plan. I tell you what, here's what we're going to do. I'm going to take a 5-minute recess. Y'all huddle, talk about that potential. Y'all huddle, talk about that potential. Check and see if Ms. Olson's available at that time, and we'll come back in 5 minutes and figure out what's going on, all right? We'll be in recess for 5.
All rise, court stands in a 5-minute recess.